morning, everybody. Thanks very much for joining Andrew and me and Radcliffe Chambers for this morning's session on restructuring. Andrew's going to kick us off with an update on the restructuring tool. We're, of course, more than a year on from that. So he's going to deal with some recent cases, the different context in which the restructuring tool is being used. Some of the challenges that we anticipated, I think, in some of our earlier talks and that we all had thought about and how those have actually played out through recent cases. And then I'm going to look at cross-border restructuring after COVID and Brexit, primarily Brexit, but of course the COVID effect is as the business protection starts to ramp down, borrowing increases, the consequences of that start to be felt, and looking at what the position is now post-Brexit, and some top tips. So I will hand over to Andrew to start with to tell us a bit about the restructuring tool.
Oh, well, thanks, Lauren. So good morning, everyone. As Lauren said, my name is Andrew Brown, and I'm a barrister here at Radcliffe Chambers. As Lauren said, we will be doing a discussion about the restructuring tool, and I've titled it an update on the restructuring tool more than a year on. So we're about 18 months or so on, a little less than that, from the advent of the introduction of the restructuring tool under SIGA. And we've seen now a number of cases which have dealt with various elements of the potentially one we call elastic clauses in the restructuring tool provisions. So we can start to see how the tool is taking shape and how it's being used going forward. So that's what we're going to kind of go through today. So I've done this little overview. I've basically said it in much quicker words by doing that. It's just going to be an update going through the recent cases rather than go case by case and just rotely go through things. I thought I would divide it up into somewhat sectional areas, so discussing specific elements of the tool we'll talk about as we've got on the plan of action here. We'll do a brief overview for those of you who don't know much about the tool. I'm going to call it the tool, by the way. Shout out to any people who love the band Tool out there. I'm not talking about them. We will talk about, though, various issues. So we're going to talk about issues of class composition, gerrymandering, which might come out of that, explanatory statements and information that has to be given to creditors prior to any sanctioning meetings. We have to talk about what's called the financial test. I put into my brief overview, we're going to discuss about the issue of, is it a compromise, whatever scheme or plan is being proposed. We'll kind of talk about that, but really when I was putting this together, I decided to delete that slide because I don't like it very much, so we'll skip over that fast. Talk about the foreign elements, and there's going to be a brief crossover there with what Lauren's going to talk about. And finally, we're going to talk about the issue of discretion, the court's discretion to sanction a restructuring plan. We've seen now fully contested, finally, proposed plans, and so we've actually got the court opining on its discretion at the final sanctions and when or when it might not approve one of these plans. So powering on, what do we have? We have the overview of the tool basics. So what is it? Well, it's similar to what we know as classically as schemes of arrangements. What the tool, the restructuring tool, allows a company to do is to reorganize its liabilities when it finds itself in or is likely to be in financial distress. And it essentially allows itself to compromise or arrange itself with its creditors in some fashion to try to avoid that financial distress, or at least soften the blow. As I said, this was brought in by the coronavirus provisions of the Corporate Insolvency and Governance Act. We all know what SIGA is, with all the things that brought into the wonderful world of insolvency back last summer, and it gets slotted into Part 26A of the Companies Act. I love how new bits of the Companies Act continue to appear from time to time as labeled as sections A, B, or C. So it slots in right behind schemes of arrangement because they're quite similar. But the real background of the tool is what's been talked about in this country for quite a while, which was an attempt to emulate the American Chapter 11 style bankruptcies, corporate bankruptcies, I should say, and essentially to allow what's known as the cross-class cram down, which is a bit of a tongue twister, which always drives me wild when I'm giving these talks. What that does, and we'll talk about this later, is it allows dissenting creditors to be crammed down, essentially, by approving creditors. So whereas schemes of arrangement don't allow dissenting creditor classes to be bound by the rules of a scheme, all classes have to approve it. In a restructuring tool, if a class of creditors dissents from the tool, says they don't want to be bound by it, all other creditors in the company can bind them to the tool in any event if the court sanctions it. So it gives the court and a company a more powerful tool of actually reorganizing itself in the face of potential insolvency in obvious big issues for certain creditors who might not want to be bound by the compromise or arrangement. What companies actually fall within the scheme of this? Well, we'll talk about this when we talk about foreign elements, but really what we're talking about is companies incorporated in England and Wales, or overseas companies with a sufficient connection to the jurisdiction. So essentially any company which could be wound up in the normal turn of a winding up petition would be liable to be bound by this. Things get more complex when we really get into matters. And a final point to make here, and something I'll bring up towards the end, is that when this tool was brought in, everyone naturally assumed, and it's generally been the case, that it's primarily been focused at large companies, companies which might have an international element, companies with a very large market capitalization, playing with a lot of money. That's generally what we've seen so far, and you'll see when I talk about the facts of some of these cases, you'll definitely know the name of some of these companies, and the money involved is often quite large. The question which we have going forward that a lot of us are working on is the applicability to SMEs. And we'll talk about some of the flexibilities of the tool and how it might apply to smaller companies going forward. So the procedure, I've written originating application on there. The reality is what you do is you apply to the court, you have to give evidence in support of that application. I call it an application. But in essence, the stage that the tool has to go through is essentially a two-stage plan. You have an initial hearing where the court will consider initial elements of the proposed plan. There's certain conditions which have to be met, which we'll talk about. Then you'll have meetings with creditors. Then matters will come back for a second hearing where the court will decide, based upon what the creditors have voted on or against, whether to sanction a meeting. So you're going to deal with certain issues at the first hearing. You're going to have to deal with issues related to class composition, i.e. how are creditors going to be broken up into various groups to vote on the proposed plan. You're going to have to deal with the information which is given to those creditors about the plan. You have to deal with the basic issue of financial test and connection of the company to the jurisdiction. At the second hearing, there's going to be the issue of the general discretion as to whether to sanction the tool or not, and also a fuller explanation of whether all the statutory conditions have been met, and if there's any issues in the plan which the court needs to take issue with. So again, this slide, I don't know what's in there, it's extraneous. I've already said what we're going to talk about. We're going to run through a very issue here. So the first thing we're going to talk about is class composition. So generally speaking, in schemes of arrangement, the way you arrange your creditors is to have as few classes as possible. And the reason is that if you divide your creditors up into classes, if one of those classes votes down the proposed scheme, then that's that. You cannot cram down or ignore a dissenting class of creditors. So what you generally try to do is you try to water down people who you think might dissent against the scheme. That's called, what in America in the Chapter 11 context is called gerrymandering. So you essentially try to manipulate the classes to make them fit what you want to make sure you can pass. Some people might be aware of this kind of behavior in CVAs as well. If you break up your CVAs into different sort of groups. Now, the other issue that comes out of this in the tool is that it's almost the opposite. Because you can cram down against dissenting creditors, you don't need to have as few classes as possible. If one class sanctions a plan, then it can cram down against another. So there's a potential benefit of having more and potentially smaller classes as well. Now, the courts have said in the past they're going to be alive to manipulation of classes to essentially make sure that no one is trying to pull a fast one by separating out specific classes to try to use the cram down when possible. This is what I call gerrymandering. I've thought about putting a picture of gerrymandering. It comes from US electoral lines being drawn up, and I believe in this country as well. I decided to ignore that desire on my part. So moving on to the actual issue of Virgin Atlantic Airways, which was the first case that we actually had using the tool back in August and September of last year, Mr. Justice Trower. And shout out to anyone from Allen and Overy who's on this talk at the moment. They got to the line first as representing the successful applicants in this case. But the background facts of this are quite well known. Virgin Atlantic Airways, obviously an airline, ran into significant issues because of coronavirus. Obviously, no one was flying anywhere. Airlines were having a big issue. So what did they do? They were about to run out of money. They wanted to use the tool. Well, they broke up the various classes into these various subcategories. They had 4 suggested classes, which I've laid out there. You had the lenders under a secured facility. You had lessors of 24 aircraft, connected creditors, and unsecured trade creditors. And what Mr. Justice Trower did was he opined upon what the proper way of actually setting out classes might be. And he drew from Part 26 schemes of arrangement. But what he essentially said is what I wrote out there, which is that the court was to take broadly the same approach as it would under schemes. The class had to be confined to those persons whose legal rights were not so dissimilar as to make it impossible for them to consult together with a view to their common interest. The question of whether consultation was possible depended largely on whether there was more to unite the relevant creditors than divide them. So you're not necessarily looking at the identity of creditors, you're actually looking at what their legal interests and rights might be, and whether they essentially share enough of those rights that they can discuss things and properly consider the proposed plan together in light of those shared and uniting interests. Well, we move on then to Pizza Express Financing 2 PLC. Obviously, Pizza Express, we all know Pizza Express, but we're talking about a very large company in this case. Kirkland and Ellis, I know there's a few of you on this talk, they handled this matter. In essence, what the tool was proposing was a debt for equity swap. Existing loans which were about to mature and essentially drive the company into insolvency. Those would be swapped over. There would be an incorporation of a new company, swap debt for equity in that. The plan was ultimately approved, but the more interesting issue for our discussion now is, again, the issue of the classes. So in this case, it was split into 3 classes. You had a plan, the plan member company, which held all the company's shares, holders of senior secured loan notes, and holders of senior unsecured loan notes. So essentially, you divided it up into shareholders on one hand, secured creditors and unsecured creditors. It's a pretty classic division, really, when it comes down to it. Obviously, secured creditors share security, unsecured creditors have 0 security. And that easily delineates between the 2 of them. Ultimately, this was approved, and moving onwards then. So Gate Group Guarantee Limited, again, as with Virgin Atlantic Airways, Gate Group Guarantee Limited, airline-related company, large international group of companies which dealt with catering to airlines, obviously ran into trouble during coronavirus as there was no catering to be done. This specific company was the English subsidiary of the Swiss holding company. There were various sort of issues to be dealt with. There was a senior facility agreement, which was governed by English law. You had various bondholders who were all governed by the law of Luxembourg, or subject to Swiss law, but they were all Luxembourg bondholders. So the courts initially was unwilling to have a single class, which is what was initially proposed. This is Mr. Justice Zaccarelli, because what you had obviously was you had the senior facility agreement, people who were governed by English law, and you had the bondholders governed by foreign law. Now, those are relatively dissimilar elements there between those 2. So it was said that this could not go forward as one class. They had to be separated out, which is ultimately what happened. So the alternative, which was set forth, and we'll talk about alternatives in a little while, was that the company, if it didn't extend the senior finance agreement and the bonds for a period of 5 years, then the company was going to go into insolvent winding up. The plan was ultimately sanctioned. So everything happened well there, but the only issue was really the class composition. So we move on then to amicus finance. Again, I think we've got a few people on the call who dealt with this, people from Pinson and Masons and Shakespeare Martin, I should say. I shouldn't call you Shakespeare's anymore. Well done to all of you. Amicus finance, so it was a company which was already in administration, but it was sort of a peculiar case because what the company did is it provided short-term property finance, as I wrote there, and the majority of its loans were funded through a trust structure. So you had people providing loans essentially into the company as trustees. They held the beneficial interest of any loans which were then given out, whereas the company held the legal interest. So there's a complex trust structure behind this company. As I know, there were 418 lenders lending into the company held under these various trusts. Well, what the initial plan was to have essentially clump two different creditors together. And the judge, again, Mr. Justice Snowden in this case, refused to do that. He said you had to separate out various lending creditors between the trust lenders and the unsecured lenders. In essence, you needed to have two classes because while they ran in conjunction up to a point, essentially up to the debt of the trust company, at that point, their interests diverged. So again, he really said you got to look at the rights of the particular creditors to see if they unify with one another or whether there's a difference between them ultimately, not just as their identity as creditors. You've got to see if there's something which unites them. And if there's difference, then you've got to have them separate. Speaking of creditors, and this is where we start to discuss issues of SMEs potentially coming into matters. Before voting, and when you initially bring your proposed plan before the court is going to consider at the first hearing the notice that you give to creditors. And accompanying the SIGA provisions was a practice statement sort of setting out in greater detail some of the matters that had to be dealt with. And the practice statement stipulates that a notice to creditors must be in a form appropriate to the circumstances of the case and as concise as the circumstances permit. Now, in schemes, notices are generally quite long and complex and obviously not suitable for smaller companies, but potentially the elastic nature of what the practice statement says about these notices opens the doors for smaller companies. It might be that if you have smaller companies with fewer creditors, in a less complex restructuring tool, your notice to creditors doesn't need to be as complex as it would be for a giant Pizza Express or Virgin Atlantic Airways restructuring. But what about the actual information that needs to be dealt with? Well, what the courts have done is they've said, look back initially to see what's talked about in schemes of arrangement. And I've specifically set out a very recent case, the case of Sunbird Business Services Limited from last year, which in fact my learned friend Lauren, who will be speaking later, was junior counsel, I should say, in opposing the scheme of arrangement. In that case, the company proposed a scheme of arrangement to offer company shares to creditors of debt equity swap in proportion to the value of the debt they had. It was conditional on the company raising cash through a rights issue of 15 million shares. But the problem was that the explanatory statement did not provide sufficient information, one, of the company's directors' material interest. And while it asserted the scheme was better than insolvency, it didn't actually back that up with sufficient information. So essentially, there were a lot of bold statements in there which weren't supported by proper information. And it wasn't disclosing the information it needed to disclose. So the paucity of information ultimately led to Mr. Justice Snowden rejecting that scheme of arrangement, although subsequently it was approved at a subsequent attempt when the information was improved. And I also say subsequently approved because no doubt that was because Lauren didn't appear at that here. Had she, then I'm sure she would have put the kibosh on that as well. But this is how we move forward with information. We need to make sure proper information is evidenced and set out in these schemes, appropriate to the matter at hand. So amicus finance, which we talked about a little bit earlier, Mr. Justice Snowden, again drawing on his own work in Sunbird, specifically noted that it's not the function of the court at the convening stage to review the contents of the statement line by line, but the judge will look at it to see if there's sufficient information to enable the creditors to take a view on the merits of the proposed plan. So if there's an issue with that, if there's a very specific issue which isn't noticed by the court, it can be dealt with at the sanctioning hearing afterwards. So especially if a dissenting creditor says, we voted against this, there was not enough information, you can have a second bite of the cherry at the second meeting if need be. But related to that, and what I was talking about in the Sunbird issue, is to actually give financial information in there to back up why, say, a scheme or tool is more advantageous to creditors than the impending insolvency. Now, what that takes us naturally onto is the issue of the financial test. So, unlike schemes of arrangement, the restructuring tool is specifically focused on issues of companies running into or likely to run into some sort of financial distress. Underlined various elements here to point out the elastic nature of these clauses. But in essence, the tool will apply to companies which must have or be likely to encounter financial difficulties that are affecting or will or may affect its ability to carry on business as a going concern. I've noted there's tons of elastic terms. There's must have, be likely, are affecting, will affect, may affect. What does all of that mean? What does likely affect? What does may mean? How do contingent debts fall into matters? So we've got some cases on this, but as far as I'm aware, none of these have been massively tested so far. The point is, it's got to face some sort of difficulty, though, either now or coming up. So Amicus Finance, again, we already talked about it. The company was already in administration, so it's already in a formal insolvency process. But what the court determined at the convening hearing was the information that had been provided by the administrators indicated that on a cash flow forecast, the trading administration was essentially going to run out of money very soon. And so it had to essentially enter into some sort of scheme or restructuring tool to avoid that if all possible. The other case I've got down is Hurricane Energy PLC. This is Mr. Justice Zaccarelli. This is an oil-related one, so you'll see again, the numbers are quite large in this case, but in 2017, the company raised $230 million via a convertible bond issue in order to actually start extracting on oil. And those bonds came due in July, or are going to come due in July 2022. Well, once they started drilling, as often is the case in oil exploration, they discovered they had significantly fewer reserves of oil than they had planned for. So essentially, it's likely there was going to be a lot less money coming out of those wells than they otherwise planned for. The evidence actually adduced by the company included a report by PwC containing a detailed analysis of the financial position of the company and the relevant alternatives such as liquidation. So at the first hearing, Zaccarelli noted that the threshold for condition A, and that's the financial test, is relatively low. It is enough that the company is likely to encounter financial difficulties that may affect its ability to carry on business as a going concern. And he was satisfied at the first hearing for Hurricane that there was a financial issue and that matters should proceed. Now, when they actually get to the sanctioning hearing, things change, as we'll talk about in a second. This is a great instance of a court not sanctioning a plan. And by the way, I've got to give a shout out again to the people from Denton's, and I think Atkin Gump, both of whom are on this talk. I saw you on the attendees list. Both of you dealt with this one. So we'll come back to Hurricane Energy in a minute, but in essence, I bring it up merely to point out that this first stage of condition A, having to demonstrate that there is financial difficulty, is a relatively low threshold. You've just got to meet that threshold that something is going to happen. And again, as far as I'm aware, no one has actually been shot down on that stage as of yet. But we'll come back to Hurricane Energy in a little while. What about foreign elements? So again, Lauren's going to talk about cross-border restructuring in a few minutes. But one of the conditions for the tool to actually apply, as I noted, is that the company has to be subject to the winding up provisions in this country. So it must either be incorporated and trading in this company, or it must have a sufficient connection to this company so as it could be wound up. So overseas companies would naturally fall in that if they've got something going on here. So we've already talked about Gate Group Guarantees Limited. That again was the airline catering company issue, where we talked about the senior finance agreement, which was England and Wales, and the Luxembourg bondholders governed by Swiss law. In that case, what Zaccaroli had to deal with was the applicability of the Lugano Convention to matters related to Gate Group. Now, the issue obviously is with Brexit coming in, some of our old means of being able to recognize insolvency proceedings across the channel with our friendly neighbors on the continent are disappearing or have disappeared. So the question was, would the matter fall into, would the matter essentially be one that it could be dealt with if we got foreign elements? And part of the issue was then considering whether Lugano actually applied to restructuring tools. Well, as Mr. Justice Zaccaroli did in his long examination of this matter, is he noted that Lugano specifically carves out insolvency proceedings as being outside their ambit. And this raised the issue of what are schemes and what are restructuring tools. So schemes have previously been held not to be insolvency proceedings and would be enforceable under the Lugano Convention. And I mentioned the case there of Magyar Telekom BV, and that's an old case of schemes. But what about in the restructuring tool? Are they insolvency proceedings? And the answer is yes, they are. And it really comes down to what we just talked about, which is the financial test. So with the financial test, what is clearly being considered by the court is whether the company is or is likely to face financial difficulties of some kind. And where the court sanction process can only exist where the company is or is likely to be facing insolvent liquidation or some sort of financial difficulties, then that brought it within the ambit of the insolvency proceedings. And so it fell outside the Lugano Convention. Moving on to Smile Telecoms Limited. Again, I think we've got people who dealt with this on this talk. There's lovely people from Latham and Watkins. Good morning. You did what is my favorite case because I love the name of Smile Telecoms Holdings Limited. This is a Mauritian incorporated holding company of an African telecoms business. I just always imagine these phones having big smile pictures on them. It's just a lovely name for a company. But the issue here again was whether the company actually fell within the boundary of the tool. It's a foreign company, so does it have a sufficient connection to the jurisdiction? This is a way of a background about what was going on here. So you've got this foreign incorporated holding company dealing with African telecoms. The issue was it was about to face a significant shortfall in cash. There was a rescue which was proposed by a large cash infusion from a Luxembourg company, but only if a certain condition which was to be met. One of the major creditors was a South African pension fund, which actually held all the money for South African government employees. And they had a put option which was about to come due. And the money would only be advanced by the Luxembourg company to save Smile Telecoms if the South African pension fund was willing to extend the put option into the future, which it was not. So you had a bit of dissent going on between the various creditors and the conditionality of the matter at hand. And we'll talk about that just in a second. But the first step that the court had to consider was the issue of connection to the jurisdiction. And what the court ultimately considered was, yes, there was a sufficient connection to this jurisdiction. And it was greatly helped by the fact that the company's liabilities to planned creditors were nearly all governed by English law with English jurisdiction clauses. So there were a ton of things out there with English jurisdiction. And that the company in June 2020, so relatively shortly before this matter kicked off, had shifted its COMI to England. It moved its offices to London, it registered with Companies House as a foreign establishment, and actually open an English bank account. So there was sort of using a sledgehammer to crack a walnut in this case. But the company had a very close connection to the jurisdiction, despite the fact that it was a foreign company. Ultimately, the plan was sanctioned. There were initial issues that Kreamer had at the sanctioning hearing as the conditionality of the money which was to be offered by the Luxembourg rescue company. That matter was adjourned out, and ultimately the conditionality aspect disappeared. That goes to the issue of sanctioning. So I see we're running out of time. We'll have to breeze through this relatively quickly. But the court sanction is the final stage of the process. So if we get through all the various conditions, we get through condition A, we get through condition B, in terms of the connection to the jurisdiction and the financial test, if we've got proper notices to creditors, if we sent those creditors out to the creditor meetings and they've discussed matters and they voted on them and they've come back then to the sanction hearing. And what's happened is either the creditors will have all approved the matter, and then things should be relatively easy to deal with at the sanctioning hearing, or you've had one or more groups of creditors which have dissented, saying they do not want to go ahead with the plan. And the court is then going to have to consider whether it sanctions the plan, including a cram down against those dissenting creditors. So if we're considering cram downs, this is where things get quite fun and fruity. The first issue is condition A. The court must be satisfied that none of the members of the dissenting class would be any worse off than they would in the event of the relevant alternative. And the relevant alternative I've talked about at various cases throughout this talk is where the court considers would be the most likely outcome if the plan was not approved. So in some cases, I've noted people have said that there's likely the company would simply go into insolvent winding up. It might be that an administration is likely otherwise. But the point is that you have to propose what the alternative might be. So there's a three-stage test then of considering what I call the condition A. You have to identify what is most likely that would happen if the plan were not approved. Then you have to determine what the consequences would be for the dissenting creditor if it were not approved. I've used shareholders, that's because in a second we're going to talk about a case where the shareholders were the dissenting class. And three, you have to compare the consequences that you consider in step 2 with the likely outcome and consequences for that dissenting class where the plan was sanctioned. So in essence, you're balancing out the two to see if they're any worse off. The condition B is the plan must have been improved by 75% in value of at least one class of creditors. We've already talked about that. So you just need one class to actually approve matters. Well, we return to hurricane energy, which we talked about was the oil company, which had run into trouble because the oil was not flowing as they had hoped it would. Just again, the basics under the plan, the maturity date of the bonds, which were about to come due in June 2022, would be extended to December 2024, and the capital amount would be reduced to £50 million. Now, to defray against that reduction, there would be a debt equity swap. So the bondholders would essentially take a new issue of shares, which would give them 95% of the shareholding of the company, which would massively dilute the actual equity in the company. So the existing shareholders would only get 5% of the company's shares, which obviously would be a significant reduction in their interest in the company. The company would then slowly undertake a winding down and ultimate liquidation. Well, as is to be expected, the bondholders, who are probably going to get paid nothing, they thought, if their bonds came due next year, were happy to approve this. And they did so in 100% approval. They wanted the 95% of shareholding in the oil company. Conversely, the shareholders did not like this idea, and 90% of them dissented. So you had two classes clearly diametrically opposed. So then the consideration was that three-step process. Well, step one, actually what the court found was there is no imminent threat of insolvent liquidation. Yes, there might be an insolvent liquidation in the future, but it was not necessarily going to happen immediately. The second issue, what the effect would be on the shareholders if no plan were actually sanctioned, was the point which is ultimately in contention. We'll talk about that in just a second. But step 3, if the plan was sanctioned, the shareholders weren't going to see anything. Their shareholding was going to be massively reduced. The company was going to be wound down and put into insolvent liquidation in any event. So it was said that they weren't going to see a return whatsoever, and they were going to be potentially worse off than they otherwise might be. So the fight was really about step 2. And what the judge ultimately found was there was a realistic prospect that the company would be able to meet its payment obligations to the bondholders while leaving assets with potential for exploitation. So in essence, it might be said that the oil would flow better, or assets could be sold, and the bondholders would have their liabilities met in a year's time. It was a realistic possibility, and that was enough to refute the contention that the shareholders would not be better off than in the relevant alternative. To retain 100% of the equity in a trading company with a realistic prospect of being able to repay its bonds and continue to trade is a significantly better position than having that equity completely diluted and seeing no return whatsoever. So in those circumstances, the court refused to sanction the plan. Last case we're going to talk about, again, fully contested case, Virgin Active Holdings. Allen and Overy, Sullivan, Cromwell, both of them dealt with this ad ints. I think there's a few of you on this call. Well done to you guys. Brown, Jacobson, and Wallace LLP. I don't know them. They never instructed me. They don't get a shout out. So Virgin Active Holdings Limited. Obviously, we all know what Virgin Active is. It's a series of health clubs throughout the country. Obviously, with coronavirus, it ran into significant funding issues. No one could go to gyms. It wasn't able to actually meet its debt, or was about to go insolvent in the very near future. What it planned to do is it planned to extend its secured debts to 2025 if the plan was approved. The general body of unsecured creditors would essentially have to compromise their debts for a payment out of the restructuring plan. And so essentially they were going to see a small return otherwise. If it wasn't approved, then the matter was the company was likely to go into some sort of insolvent liquidation. So this was fully opposed, as I've noted. There were 7 classes of creditors in this case. There were the secured creditors, the existing landlords, and those existing landlords were actually split into 5 different classes based upon the profitability of those specific clubs, because the return to them would be based upon that profitability, and then the general body of creditors. The secured creditors and Class A landlords, so those landlords, the most profitable sections, actually approved the matter, but the other 4 landlord classes and the general creditors disputed it. They did not approve it. So then the issue became whether they could be crammed down or not. Well, so we had to go back to condition A. The most likely relevant alternative to the restructuring plan was an administration involving the accelerated sale of most of the valuable parts of the company's businesses. What the result of that would likely be is that, well, the secured creditors would see a return, and maybe the Class A landlords, but the other landlords and the general creditors would see absolutely nothing as a result. And this really hinged, this was the biggest issue, and this is an issue of evidence, is the valuation and calculation of the plan company's evidence appeared to be reasonable and capable of being relied upon for the purposes of determining whether to sanction the plans. In essence, the company put forward valuations of its assets, which indicated that only the secured creditors would actually see a return in any administration. The dissenting landlords provided no competing evidence as to the valuation of those assets. So the court could only go off the evidence which was in front of it. Now, I've laid out the factors that the judge actually considered here. So Part 26A gives little guidance on the factors which are relevant to its discretion. But in essence, since the opposing landlords and general creditors would be out of money in the relevant alternative, the court attached very little weight to their numerical opposition to the plans. For the same reason, their objections to what the secured creditors had agreed as a compromise carried very little weight. So in essence, the landlord should have put in some sort of evidence which disputed the valuation evidence and actually indicated they would have seen some sort of return in the administration. in essence, it's for the creditors who are in the money to determine how to divide up any value for potential future benefits. And the use of the business and assets might generate post-restructuring. The differential treatment between landlord classes was explained by reference to the profitability and commercial importance of the planned companies attached to the relevant clubs. So again, going back to class composition, what unites the various subcategories of creditors? In this case, it was looking at the profitability. What are their rights? What are their impacted rights? What unites these very specific creditors? There was nothing inappropriate in choosing plan rather than a CVA. And the retention of equity by the shareholders was predicated on a substantial new value offered by the shareholder, where the court accepted that the new money lent by the shareholders could not have been obtained on the same or better terms from any other source in the market. So there we had an actual fight over the discretion.
Hello again, everyone. So as Andrew mentioned, as I mentioned at the start, I'm going to be talking about cross-border restructuring post-COVID and post-Brexit. I think the reason people will appreciate that the COVID element has particular relevance, I think, is that we're starting to see the ramping down of various kind of governmental financial packages. And so we're starting to see, what the real aftermath of COVID in terms of finances is. So I'm going to go through sort of a brief overview of cross-border restructurings, what it is, just an outline introduction, the position before Brexit, the position after Brexit, some thoughts on what I think is potentially going to happen next, and then some tips on cross-border restructurings if you're involved in them. So, as I said, cross-border restructuring after COVID. As many of you will know, having been intimately involved in these yourselves, a reorganisation of a company's liabilities, and often, not always, where the company's in financial difficulty. The essence of it is it needs to be an agreement between the company and its creditors, or some of them. And you've heard a lot from Andrew about that, and about the mechanisms by which dissenting creditors can be compelled to comply with or be part of these arrangements. What makes it cross-border? Clues in the name, where the company has interests or assets in another, more than one jurisdiction, for our purposes, another one other than ours. And as you will know, cross-border restructuring, any restructuring, can include a range of tools or methods or forms. So statutory procedures like the restructuring tool that Andrew's taken you through, refinancing arrangements, debt for equity swaps, closing down parts of the business, moving parts of the business around the place, essentially any arrangement that you propose and is agreed to by creditors. So I had a look into where we are now, and there were some pretty interesting figures. Good Bloomberg report on what the finances are. Record levels, it won't surprise anyone to hear, of corporate debt issuance in 2020. The EU alone added 400 billion euros in debt in the first half of 2020. And as I've put there, the figure for the year before was 289 billion for the entire year. So you sort of start to see that, looking at 3 or 4 times where we were in 2019. And there has been fiscal aid for the G20 countries alone of around $10 trillion. And those are the sorts of support packages that are now coming to an end. And of course, we will start to see some of the sort of zombie effect of companies that have just been kept going by those aid packages, and those will go under. But there will be plenty who will also realise that they've taken on this huge amount of debt, and they're going to need to restructure to allow the business to continue. McKinsey asked 114 European restructuring experts what they thought about all this. And it won't surprise anyone to hear 92% thought that there was going to be an increase in restructuring activity kind of now and through the next 12 months. There are, of course, sectors where it's pretty obvious that we're going to see those increases, and already are seeing the increases, and they're the ones that were hardest hit by COVID. And you see that in the cases that Andrew took you through, the sorts of industries, your gyms, your restaurant businesses, energy companies, all those kinds of businesses who we're starting to see the effect for, who've been most strongly or worst affected by what's gone on. And sort of slightly interestingly, about half of the respondents to that survey said that insolvency would be among the 3 most likely restructuring solutions, which suggests that there's plenty of people who think there are other options out there, right, rather than insolvency for these companies. So that's kind of the landscape that we're talking about, and the reason that I think it's worth talking about this today, because I think we will start to get a lot more questions from companies who are wondering what their options are, who know that their position is untenable, but don't really know what the alternative is. So the position pre-Brexit, we're talking here about recognition. Now, Andrew outlined that helpfully a little in relation to the restructuring tool. Essentially, and most of you again will know this, but just as a brief outline, it's ensuring that a restructuring for present purposes process is recognised and effective in other jurisdictions, and importantly that includes recognition of judgments handed down, and I'll come on to a bit more onto why that matters for now. And it's also a court giving effect, or the process by which a court gives effect to a foreign law or an order of a foreign court, so sort of the inverse of the first way of framing it. Now, most large restructurings have or many, maybe not most, but many large restructurings have that will be coming across, have a cross-border element, and actually lots of SMEs have a cross-border element. So I think we're going to see more and more instances where we need to take cross-border specific factors into account, and of course, we're all aware insolvency regimes in different jurisdictions vary very significantly. So it's no good basically starting off, advising your client who's come to you that well, the restructuring tool is the way for you, or whatever it might be, only then to realise that can all be circumvented effectively by a major creditor in another jurisdiction where other assets are, starting insolvency proceedings and sort of effectively tanking the whole process. I think the other thing about why it matters is thinking about just the realities and the practicalities, having valuable assets situated in other jurisdictions, having legal proceedings threatened in other jurisdictions. You start to see as well that if you have parallel proceedings in different jurisdictions, then you're going to have uncertainty. And of course, for your clients who are trying to implement restructuring, the whole point is to have certainty. You set out exactly, hopefully, what you're proposing to do, and you ask your creditors to agree to it, and they ideally do, and then you know how to move forward. And to have that alongside other proceedings where a totally different approach is being taken or outcome can be achieved is obviously not going to be on anyone's list of aims in this process. So pre-Brexit, the position was this. Recognition was automatic, so it was all pretty straightforward. It was all fairly cheap. You didn't have to deal with sort of different proceedings in different countries. And a good example of that is Nortel. Nortel was the UK administrations of 19 network companies, group companies, throughout 16 EU countries. And what happened in that case was that the court authorised the administrators to send letters of request to foreign courts, and that required notice of any request or application for the opening of secondary insolvency proceedings in relation to any of the companies in administration, and also importantly an opportunity for the admins to be heard in any of those cases, so to arrange representation in whatever member state it might have been, and so that would have allowed them then to make submissions, to say, here's what this is going to do. This will ruin the administration for this reason. This will defeat the purpose of what we've been doing for a long time, or whatever it might have been. And it just gave a degree of control over the foreign proceedings. And that was possible through recognition. And that was in the EIR and Brussels recast, which I won't go into in any detail. Many of you will be intimately familiar with them. But that regime of reciprocal recognition meant that you didn't have these parallel proceedings, and also sort of had the answers. You could say, well, what is the position with recognition? You knew that the EIR and the Brussels recast were what applied. You could go and have a look. Straightforward and cheap to work out, as opposed to probably what we have now. And you had the guiding principle, which everyone will be familiar with, of COMI, the centre of main interests, dictating the location of the proper forum for the proceedings. So post-Brexit, the EIR and Brussels recast are gone. For any insolvencies or proceedings which commenced, restructurings which commenced after the end of the transition period. So some of us are still dealing with pre or during transition periods restructurings and proceedings, and we've still got the old regime for those. And of course, typically, issues of recognition and those sorts of things are have been sort of worked through in those cases already. But so those are what you'll often see them referred to as the in-flight cases. So the post-Brexit position is relevant for, and that should say, for proceedings commenced after that date. That's the legislation I've set out there, the regulations, 2019 regulations, which repeal the majority of the provisions of the EIR, including, importantly for present purposes, the regime for automatic recognition. So technically speaking, the EIR still exists in law, but it's a shell. Effectively, it doesn't serve the function it did in certainly as regards recognition, but also in pretty much any other regard. So what do we do now? Well, we have the United Nations Commission on International Trade Law model law, people call model law on cross-border insolvency. You can use that, and that contains recognition provisions if it's been adopted by an EU member state or by another country. There are only 4 EU member states that have adopted it, and they're the ones set out there. I have done and come across restructurings that have involved entities in some of those countries, but also, or typically alongside other EU countries that are not signatories. So it's useful only insofar as it goes. If you happen to have one where the cross-border entities are, in Greece and in the UK, then very much worth brushing up on your model law. Similarly, US, Australia, Canada, New Zealand, Singapore. So some, big players globally, but for the EU, not so helpful. And we've, as I say, we are a signatory, and we have given effect to the model law by the cross-border insolvency regulations 2006, which we'll mostly be familiar with. But even under model law, it's not automatic. Recognition isn't automatic, and different countries, as you see from us having implemented it by way of the cross-border insolvency regs, different countries can sort of adapt it to suit their own purposes or frameworks. So there's also private international law. Again, it's not a common, or there's no common or standardized position. It's country by country. It's a return effectively. A return effectively to a non-unified process. And of course, the reason we care about that is that it's expensive. It takes a lot of time, and it requires you to sort of obtain the relevant knowledge for each of the relevant jurisdictions that you're involved with. So for the EU, it's member state by member state again. Now, for the EU, the Insolvency Service produced this outline guide, which people on this call may well have been involved in producing. They got help from Ashurst, certainly, maybe other firms in this country too, but certainly sort of different firms across the EU. And that gives you a sort of outline view. I think it's fair to say that for many of the jurisdictions, not all, some of them are much more detailed, but for many of the jurisdictions, it's, a paragraph or two to sort of tell you or give you a bit of a steer. So that's sort of helpful so far as it goes. I've put the link there, and I think the slides will be circulated after the talk, so you can have a look at that if you're interested and it's relevant. So that's a bit of a whistle-stop tour through the background. I know many of you will know the issues and will understand. Oh, and I should have said as well that I gave this talk. I've given this talk, similar talks at different times, and for a long time I had a slide that talked about the Lugano Convention and that being a bit of a hope for us potentially in terms of its provisions. We had applied to join Lugano and the answer was no. Unsurprisingly, it needed consent from all of the EU member states. So no Lugano. So that's not an option, but some of you may have seen that previously being floated as a possible save is probably too strong a word, but means of getting around some of these issues. So the future, where do we think this all takes us? I think the answer, if you're dealing with other EU member states and countries that haven't adopted model law and that we don't have where we don't see those reciprocal arrangements, there may well be parallel proceedings, which gives rise, of course, to more complication. That's less likely to matter in a way if it's a very large-scale restructuring, because it will be very expensive anyway. It will require a huge amount of specialist knowledge, and frankly, factoring in taking advice from French lawyers or whomever is unlikely to make any difference as to whether you're going to sort of proceed with this or not. But I think will be more of a consideration where you're dealing with SMEs who are often very cost conscious, and for them there's no point in these restructurings being commenced if the cost of them is going to snowball out of full proportion to the actual process itself. So potentially a consideration more at that level. I think we will see moving COMI to a member state. It's entirely possible. Andrew outlined it in relation to a couple of the cases, to the Smile case in particular. You can change the location of a company's COMI before implementing these kinds of procedures. It's known as forum shopping. It's changing centre of main interest of a country to a jurisdiction with a favourable regime for the purposes of what you're doing in insolvency restructuring. But you might want to think as well, I'll come on to this, but there will be other ways of protecting assets, for instance. Filling the void, the Netherlands have already implemented a new restructuring plan, a sort of scheme type restructuring process. Germany is I think still in the process of doing that itself. So in much the way that we sort of saw people try to fill voids that were left after Brexit in various regards, as a financial centre, for instance, you saw the likes of Frankfurt and Paris stepping in to fill what they saw as a potential void, at least. I think we will see the same thing. We are seeing it, we'll continue to see it in EU member states. The less drastic view, I think, is that there's not going to be masses of change. The restructuring tool, for instance, has been extremely popular. You can tell from the amount of cases Andrew had to talk about. It's not been around for very long, and already you can tell the level of usage it's getting and the profile of the usage it's getting. And we also have that and probably part of the reason that this was introduced, the sort of cross-class cram down. Other countries don't have that, so there are unique elements of the tools that we have, and there's a uniqueness about our system, the expertise we have. I have no doubt that it's going to continue to be valued, and I think particularly the fact that insolvency and restructuring has shown itself to be relative to other areas a fairly adaptable area of our law. I think means that people are not going to lose all hope with us and immediately jump ship. They will have to see what the Gate Group decision that Andrew referred to does in terms of recognition and choice of forum shopping and choice of jurisdiction. So some tips or some planning points, some points to think about if you've got clients who are looking at restructuring and restructurings with a cross-border element. I think, like any case, the finding out what their short-term and long-term goals are has to be the starting point for restructuring. You know, short-term, you need to understand whether there are protections, moratoria that you need to put in place beyond, you know, the obvious, we don't want to go bust. Working out as well where the company has its assets. I think that's also fundamental, because if there are key assets, and of course there always will be, you can think about transferring those assets out to other companies within the debtors group that isn't likely to face insolvency proceedings, or alternatively to a company within the group where the COMI is more favourable for your purposes. I tend to think it's useful to kind of set out a jurisdictional list, an asset list, work out what they've got, where it is, and where the risks are, so that you can try to mitigate those risks right at the outset. And of course, working out where the COMI is absolutely fundamental, and deciding whether you're going to opt more for transfer of assets or transfer of COMI. The latter is sometimes more drastic, but that forum shopping process needs to be worked out very early on. And as part of that, you're thinking about, you know, are we going to do all this only for some French creditor to come along and manage to frustrate the whole thing by commencing insolvency proceedings over there? So I think that's another important thing to think about early on. But I think you can sort of prepare as much as you like. And the last point I've put is emphasising to the client the importance of thoroughness and preparedness. Andrew outlined the Sunbird case, which I worked on last year. And I think that would have been a very good idea. I think Hayley from Shoesmith is on the call, and she instructed me on that case. And I think the thing we all took away on that was that preparedness and being thorough and making sure you're providing all of the relevant information at the right time is just absolutely critical. And Mr. Justice Snowden, his judgment made that abundantly clear. But there will be things that crop up, even if you're thorough, even if you're prepared, even if your client's given you all the documents and all the information you need. You've got to have a plan B, because there can be all sorts of changes that happen through the course of a restructuring, and particularly in a cross-border restructuring, which will often feel a bit more nebulous. You know, you may end up with changes in the identity of creditors, because if the group is still trading, then that's an inevitability. There are people behind all of these things, stakeholders, who may change their minds. Things can change midway through, and particularly in a case like coming back to Sunbird, you know, if you have a scheme that you've approved as a creditor, you've voted for, and then the court doesn't sanction it, that sort of thing gives you pause. And there are always potentially changes which arise out of anything. People are skittish in these sorts of circumstances. Publication of new financial information is something that often also throws things off. So, you know, while you may know here what the position is in that regard, you need to make sure your ducks are in a row, and to make sure that, you know, the German accountants don't get ahead of themselves and publish things that are going to have an effect on what you're trying to achieve. And so all of those things, you know, just outline the need for a plan B, a contingency plan. And one ideally which you can put into place without the involvement or the consent of the stakeholders who you're worried about, or which circumvent the sorts of issues that I've outlined. And those things can also themselves provide some reassurance to any worried creditors or stakeholders. It's often, you know, people are trying to balance their own interests, and of course that's what the court does in relation to a lot of these schemes, is trying to balance the interests of lots of different people with lots of different approaches and attitudes. But trying to anticipate, it's difficult, but trying to anticipate as many of those things as possible, including where necessary by taking foreign legal advice, is always a good idea.
So thanks very much everyone for coming. I've been Andrew Brown, and Lauren has been right. Have a lovely day, everyone.
Thanks everyone. Take care.